Hey, Amazing Law Nerd. Welcome back to the Emily Show. We have a lot of case updates to go through today, including some updates from the Ohio Supreme Court in the Mackenzie Shirilla case. I talked about that with relation to the Netflix show, The Crash. We have some updates in the David case. I'll explain what they mean. Some things going on in federal court in the Bricks and Minifigs, Reckless Ben of it all. And then one other quick update in the TikTok psychic appeal, because of course there's an appeal. So lots on the docket today. Let's get into it. I'm legal analyst Emily D. So the singer David, spelled D4VD, David Burke, was back in court in Los Angeles on July 7, 2026 to see if the preliminary hearing would be going forward at the end of the month of July. And after numerous continuances, it seems that the preliminary hearing will be going forward. Neither side has moved to continue. The court has set aside numerous court days for this preliminary hearing. Remember, David is charged with special circumstances murder for the death of Celeste, who was 13 at the time when she was killed. The prosecution has alleged that that was a special circumstance murder for pecuniary gain, monetary gain, and the killing of a witness, alleging, as I have covered elsewhere, that Celeste was going to expose the relationship that she was having with David, or that he had groomed her into, and she was threatening to blow up essentially his music career. Prosecutors allege that he murdered her to silence her in that, to maintain that career, which is the monetary value. But they were back in court. The defense and prosecution have discussed that much of the discovery has now been turned over, that the discovery that's going to be going forward in the preliminary hearing has been turned over, and the court set some dates. I am looking at an article from LA Magazine. They have had reporters in the courtroom at all of these hearings saying that Deputy District Attorney Beth Silverman estimated that the preliminary hearing would take 5 days or less. Judge Olmedo set the schedule for July 21st and 22nd at 9 a.m., July 23rd and 24th at 9:15 or 9:30, July 27th at 9 a.m., and then July 30th and 31st at 9 a.m. if needed. The court noted that July 29th may be dark, which means the court probably has other things that would interfere with that day. And then DA Beth Silverman told the court that she would be out of town July 31st, but didn't anticipate the preliminary hearing lasting that long. Defense attorney Blair Burke told the court that the defense has received a substantial amount of digital discovery, all of the detectives' written reports. Burke said that prosecutors mentioned not every piece of evidence may be produced because of the volume of the digital material. She told the court that they assured the defense that it had received all evidence deemed relevant, which means there may be things coming in, but those aren't things that the prosecution will seek to use at the preliminary hearing. The parties told the court that they reached an agreement on a protective order covering the handling of evidence, which will be submitted to the court for approval. That makes sense. We know that there are sensitive images of the victim in this case, among other digital discovery, based on the prosecution's written motions. The defense also brought up in that hearing whether or not defendant David would be restrained or shackled during the hearings. The court said that she wasn't going to address that on July 7th, but if the defense wanted to file a written motion, that they were welcome to do so, and the court would then consider it. Oftentimes you see, especially when cases are televised, that the defendants are not shackled so that it does not seem as if they were already guilty. It's meant to neutralize the defendant's presence in the courtroom, particularly in front of a jury, or if cases are televised, in front of potential jury. However, at a preliminary hearing, that's not an issue, because at a preliminary hearing, there is no jury. A preliminary hearing is not a trial. It is a finding of probable cause. It is a limited hearing. Sometimes you will have civilian witnesses. Often you will just have law enforcement witnesses who will establish the probable cause, that is, did this defendant most likely commit the crimes that are being charged here? It is a threshold hearing for the case to move forward to trial. In a lot of jurisdictions, this is done at a grand jury proceeding where a grand jury passes down an indictment. A preliminary hearing is different in that the defense is a part of the preliminary hearing. They can make objections. They can cross-examine witnesses, where at a grand jury, it is just the prosecution putting on evidence. But the rules of evidence are still somewhat limited at a preliminary hearing. The judge is the finder of fact there. The judge is the finder of probable cause. There are differences in the way the rules of evidence work at that probable cause hearing, and it is to function to bind over a defendant for trial and ensure that there's enough evidence to do so. It is unusual but not impossible that cases get thrown out at preliminary hearing, but if they do, the prosecution always has the option to refile them. So this is not a mini trial. This is a facial showing of what evidence the prosecution has, and it's the defense's first opportunity to cross-examine some of those witnesses and make sure that the prosecution is putting in evidence and to see the way that the prosecution is going to put in that evidence. I imagine that this case is going to be heavily based on digital evidence, and we'll probably see a lot of that at the preliminary hearing. And to answer the question you're all going to ask, Emily, will this be televised? No. Judge Olmedo has already said that because of the nature of some of the additional charges to the murder charge, including the ongoing sexual abuse of a minor, this case will not be televised. The courtroom will be open, but I imagine a lot of the evidence that may be shown to the court during the preliminary hearing will be sealed, meaning it will be submitted to the court. It will not be on screens in court. It will not be for view of the public, which is appropriate given the types of evidence we might see and what the charges are that that evidence supports. So yes, the courtroom will be open to the public. No, it will not be televised. No, there will not be cameras in the courtroom for the David case throughout this case and through trial. So what will happen at the preliminary hearing? Well, I expect that the case will get held over for trial, and then they will start picking trial dates. And after that, the prosecutors will then have their special circumstances committee hearing and decide whether they are pursuing this case as life without the possibility of parole or as a death penalty case. And yes, they can still pursue the death penalty, though there's a moratorium in California on that being carried out. It is still law on the books in California, and the prosecutors can still pursue this case as a death penalty case if they choose to. That decision has not been made yet. Also, possibly related to the David case, we started hearing at the end of the week, last week, that there is an investigation going on at the LA County Coroner's Office. We're going to take a look at that real quick. This is also coming from reporting from Los Angeles Magazine, and I started seeing rumblings of this at the end of last week that more than a dozen employees of the Los Angeles County Department of the Medical Examiner, the Coroner's Office, are reportedly under investigation after graphic details from the homicide investigation into 14-year-old Celeste Rivas Hernandez were leaked in past media reports before the official autopsy report was made public. Remember, in this case, law enforcement very early on moved to seal the autopsy report even before the autopsy report was done. And I was critical of reports talking about whether or not Celeste had been dismembered in any way and the state of her remains. But there were reports floating out there well before anything came out from the coroner's office. And in fact, the coroner's office pushed back pretty heavily on LAPD for sealing everything. The coroner's office put out numerous statements that I covered saying this is not how we do things. We do not seal things. Though when we have a minor victim, I am less critical of sealing things, especially before anyone is charged with a crime, because for a while, LAPD was saying, look, we need to make sure that we are dealing with a homicide case versus dealing with potentially an accidental death and then a after the fact crime like disposing of a body, etc. So there was restraint, I think, on the part of law enforcement, and there was some pushback on the part of the coroner's office. And now there is an investigation into the coroner's office, which is unusual. Reporting goes on to say that according to NBC4 Los Angeles, investigators and administrative staff have been ordered to participate in recorded interviews as part of an internal probe into whether they accessed confidential law enforcement investigative files without permission. All access to computers are going to be logged. Like, you're going to have to log in with a number that tracks what you're accessing. So I imagine that's already been pulled, and they can see that there's digital access that there should not have been. Because yes, the coroner will have access to police reports, but that does not mean everyone at the office can just pull the police reports in a given case because they're curious. That is outside the boundaries of what they are allowed to do. The coroner directly working on the case, yes, everybody else, no. They go on to report that throughout the course of the Rivas Hernandez investigation and prior to the singer being arrested, there were leaks and speculation via the media that the teen's body may have been frozen, decapitated, or other sordid details. Multiple sources familiar with the matter stated that the investigation is being conducted by the LA County Department of Human Resources. I bet this started with IT, though. They say that the medical examiner's department declined to comment on the reported investigation as it's ongoing. Any internal investigation is going to say the same thing. They go on to say, if confirmed, the medical examiner personnel investigation would be separate from the criminal prosecution against David Burke and is focused on whether confidential records were improperly accessed or viewed by county employees. No employees have publicly been accused of leaking information, and the reported probe remains ongoing. I'm interested to see where this goes. The big question will be, well, if there was impropriety in looking at documents that somebody shouldn't have been looking at, can this impact the prosecution against David? Lawyer Emily says it depends. However, if it is the coroner that's testifying, because generally the only person from the coroner's office that would be testifying would be the coroner themselves has access to law enforcement files. That's proper. We have seen that in case after case where law enforcement provides the police report to the coroners. Sometimes they look at it, sometimes they don't. They use it in different ways depending on the situation, the case, and who the coroner is. So the coroner doing the autopsy is allowed to access those things. It is someone not working on the case accessing documents and then leaking them to the media that seems to be at the heart of this consideration. So will this undermine the testimony of the coroner doing the autopsy? Likely not, unless that person was the leak to media. And then you can see defense questioning, perhaps, if that is the case. This would all be vetted at 402s before this ever came in front of a jury. But why would you leak that to the media? Did you want to push for an arrest of David? Did you rule this case a homicide versus an accident because you wanted to push forth a prosecution? You could see those things coming up in cross-examination if the person doing the autopsy and testifying was the one who leaked it, which we do not know. And I would suspect that it wasn't, because the coroner doing the autopsy knows how critical going to court is. So I'm curious to see how this plays out, but what we don't need is people accessing records that they're not authorized to do because they're curious. And we've seen investigations like this in other cases, but not from the coroner's office. So I'll keep you posted. Leonard, a quick break to thank today's sponsor, Honeylove. You know how much I love Honeylove's bras, shapewear, and sleepwear. And of course, we've got a great deal for you. You want to feel supported while feeling comfortable. And I love how supportive yet lightweight the materials are that Honeylove uses. I'm not surprised that Honeylove meets our needs as we age and as the weather gets spicy, because it's a female-founded brand. You are going to want to check out the new crossover contour bra and the Cloud Embrace bra. Both are game changers. The crossover contour bra combines the best-selling wireless design with molded foam cups to create a smooth, natural shape. And the Cloud Embrace bra is soft, breathable, incredibly comfortable, and supportive enough to replace your old underwire bras. And you know that Honeylove has the shapewear that I rely on for special events, because at the end of the day, Honeylove knows that it isn't about changing your body. It's about supporting you in a way that actually feels good. And do not sleep on the sleepwear. Absolutely love it the most. It has replaced my entire pajama drawer. Leonard, I know you're ready to treat yourself to the most advanced bras on the market. And when you use our exclusive link, you get 20% off Honeylove at honeylove.com/Leonard. That's honeylove.com/Leonard. And after you check out, if they ask where you heard about them, let them know it was The Emily Show. Experience the new standard in comfort and support with Honeylove. And now back to today's show. So, have you been seeing conversation about the Mackenzie Shirilla case that was covered in Netflix's The Crash? Again, we talked about it a little bit a few episodes ago, and the untimely appeal that was going to the Ohio Supreme Court because her lawyers filed their appeal arguing that trial counsel was essentially ineffective, their ineffective assistance of counsel appeal, to the court one day late. And then they turned around and argued, Your Honors, it's a leap year. It's not our fault that this was filed on day 366, not day 365. And that was not persuasive to the court. And they were appealing it up to the Ohio Supreme Court, saying, Your Honors, allow the appeal to be heard on its merits. Do not cut this appeal off on procedural grounds that it was filed literally one day late. Because leap year. Well, the Ohio Supreme Court filed their order. And they did exactly what I thought they were going to do. Denied. It's untimely. The Ohio Supreme Court on June 23rd, 2026 said, quote, and this is the entirety, upon consideration of the jurisdictional memoranda filed in this case, the court declines to accept jurisdiction of the appeal pursuant to Rule 7.08b4. We will not hear your appeal. No, which means the ruling of the lower court that this is untimely stands. So they don't want to hear argument. They don't want any more filings. We are not accepting jurisdiction. And that was the argument that we thought was going to be most persuasive. Well, Mackenzie Shirilla's attorneys are not satisfied with that answer and filed a motion for reconsideration on July 7th, 2026. In brief overview, and if you want a deeper dive into what's going on with this appeal and into the underlying ineffective assistance of counsel arguments, which a lot of you said you did the last time I covered this, let me know. We will docket it for stream and go through all of the arguments. But in sum, the motion for reconsideration is arguing that because Mackenzie Shirilla was convicted in the jurisdiction that she was in Ohio, the interpretation of the 365-day rule, because the law does not say a year, it says 365 days. And they find that that is 365 days, not 1 year from the date. That if she had been convicted elsewhere, there are other jurisdictions in Ohio that interpret that rule differently. So now they are arguing that there is a split of authority in Ohio where some jurisdictions would have allowed this appeal to go forward. It would not have found that it fell outside of the time by a day. And so because there's a split of authority, they are arguing that the Ohio Supreme Court needs to take the case up, needs to hear the case and resolve the split of authority. Because essentially, if she had been elsewhere in Ohio, she would be allowed to proceed on the merits, saying that there was ineffective assistance of counsel at trial and not barred on procedural grounds that this was too late. So they are now appealing to a split of authority. We will see what the Supreme Court does. The Supreme Court may well likely say, we are disinclined to acquiesce to that request and we are not taking this up on appeal. Emily, if the Ohio Supreme Court decides that they don't have jurisdiction because it was filed one day too late, what happens to the merits of appeal? Nothing. The merits of appeal do not get heard by any courts of appeal because the courts no longer have jurisdiction because the time has lapsed. Let me know what you think. Half of appellate work is timelines. And this is a pretty big one. And speaking of appeals, a number of you have been asking me, Emily, wasn't the TikTok psychic who lost a $10 million jury verdict for defamation of a professor at the University of Ohio, wasn't she appealing? Yes. Wasn't her appeal due? Yes, it was due June 29th. But on June 29th, the very last day, she filed improperly, but she filed a request for more time. And the court said, you filed it improperly, but we kind of get what you mean. This is the correct one. We'll file it ourselves. You have 30 more days. So her opening brief for appeal is now due at the end of July. So I will keep you posted when that's filed or if there's another request for more time, but the court often will grant a few continuances. We've seen this in a lot of cases we've covered. So we're going to wait till the end of July to see if the TikTok psychic files her opening brief in her appeal of that jury verdict. And finally, moving into federal court real quick with what's going on with bricks and minifigs. I've seen a lot of confusion about something the court docketed, and by the time this airs, this may have resolved, but I wanted to talk about it real quick because we are talking about diversity jurisdiction in this case. Remember, Reckless Ben's attorneys took the case from state court and were like, hey, we have diversity jurisdiction. We are going to federal court. Goodbye. And it seems like that was a really solid plan because in addition to what the court has asked for, which we are going to cover, the court also signed the motion to change that horrific temporary restraining order. And now the temporary restraining order has been significantly limited to a much more normal temporary restraining order, which is things like you can't harass the other party, you can't threaten the other party. But it also says specifically, nothing in the preliminary injunction shall be construed as a waiver of any party's defense and rights to pursue past, present, future claims and damages against any other party. So they're not waiving their rights. And nothing in this order shall prohibit defendants from discussing plaintiffs, defendants Reckless Ben et al., including Brian Mansell, commenting on this litigation, publishing court filings, like I'm doing now, engaging in investigative journalism, expressing opinions, criticism, satire, and/or commentary through any lawful means or methods they choose, including but not limited to YouTube, TikTok, Instagram, and podcast, and/or other internet, television, radio, and social media platforms. The reason this only says defendants is because that temporary restraining order was only restraining defendants from speaking. It's why you've seen some of the plaintiffs continue to give interviews even after the temporary restraining order was in place. The only ones restrained were the defendants, and now that has been signed by the federal court, which undoes the lower court order that was in place and lifts those restrictions and really does limit it to no doxing, no harassment, no death threats, which really wasn't a problem here anyway. That doesn't change the fact that Reckless Ben still has numerous criminal cases against him. We've gone over the filings in those, which are pretty clear about what he's being charged with. And we went through some of those affidavits briefly of probable cause, but those criminal cases are still proceeding. However, there was another question about a clarification the court filed that seemed to cause a lot of concern and, well, confusion. I understand. This order from the court was filed July 7th, 2026. And again, this may be resolved by the time this episode airs because it's a pretty easy issue to resolve. The memorandum decision and order from the court states that the defendants removed this action to federal court on June 26, 2026. And then they cite the notice of removal. The notice of removal asserts that this court has jurisdiction based on diversity of citizenship. In part, the notice states that, quote, defendant Reckless Ben LLC is a California limited liability company. And then they go on to quote, for entities other than corporations, the court's diversity jurisdiction in a suit by or against an entity depends on the citizenship of each of its members. Moreover, where an LLC has as one of its members another LLC, the citizenship of unincorporated associations must be traced through however many layers or partners or members there may be. This is me. An LLC is made up of its members versus a corporation, which has corporate personhood. So where the corporation is located is sufficient. But because an LLC is made up of its members, what Reckless Ben's attorneys did not do is state each of the members of the LLC and where they reside. If any of the members of the LLC are Utah residents, then you lose complete diversity on either side of the V because plaintiffs are all Utah and then defendants are all not Utah. You just need not Utah. So the court is just asking for clarification of where the members of the LLC are. And if Reckless Ben LLC is just a single member LLC and that single member is Reckless Ben, well, Reckless Ben is domiciled in California, and so that's not going to be a problem. They just need to file the documents to show the court that all of the members of the LLC, whomever they may be, are all domiciled not in Utah. The court says the notice of removal does not state the citizenship of each of the members of defendant Reckless Ben LLC. Until defendants show the citizenship of Reckless Ben LLC members, the court cannot ascertain whether it has jurisdiction over the matter. Accordingly, on or before July 21st, defendants shall show citizenship of each of the members of the defendant LLC, Reckless Ben LLC, to show diversity. Otherwise, this case will be remanded for lack of jurisdiction. So they have until the 21st of July to file their notice to the court of where the members of the LLC are domiciled, which, as long as none of them are in Utah, it's not going to be a problem. Now, if any of them are in Utah, then this might get remanded back to state court. But in the meantime, that horrific TRO that I've complained of so much has been superseded by a much more normal preliminary injunction saying, don't do things that are illegal. Don't dox. Don't make death threats. Don't harass. But you can talk about the case and you can continue on with the First Amendment rights that one would expect to be protected by the courts. I don't expect that this will be a difficult hurdle to meet. They have some time to do it, and we will see where it goes from there. But this is a fairly easy thing to overcome, but the courts do need to make sure there is complete diversity of citizenship. That's not going to be difficult to do. I suspect it will be done before the 21st, and I will keep you posted. Let me know if you have any questions about these cases, and I will talk to you in the next one. So thank you for being here. Thank you for being a law nerd, and I'll see you on stream later this week or out on the road because, EDB Travels to Watch DCI is what we're doing this summer. I'll see you soon. Thanks for joining me. If you enjoyed this episode and don't want to miss updates on your favorite cases, you're going to need the Law Nerd app at lawnerdapp.com. That way you can stay in the loop on the cases that matter most to you, and you never know when you're going to catch feelings for a new case. So make sure you get it for free on iOS and Android. Thank you for being here, and thank you for being a law nerd.